Good afternoon. Welcome to the 2024 Legislative Review hosted by the Nebraska Court Improvement Project. My name is Deb Van Dyke Reese, and I'm the director of the Nebraska Court Improvement Project. And I wanted to do some housekeeping items before we get started today. If you do have questions for the presenters, you can utilize the Q&A tab on Zoom to provide those questions to the presenters, and we'll answer them as they're able to. This webinar is being recorded and will be hosted on the CIP YouTube channel. And it will be there by the first part of next week. And I want to have a very big thank you to Mary Pat Coe and Teresa Cusick from the CIP team who helped to organize this legislative review. And I also want to thank all of our presenters for sharing their knowledge and sharing their information for today's webinar. Next slide, please. So what is CIP? I wanted to provide an opportunity to just give an overview of the work that the Court Improvement Project does. The Nebraska Court Improvement Project is part of a nationwide network of court improvement projects that are all housed underneath the Administrative Office of the Courts across the country. And we do our work in a variety of different ways, but we utilize data. We provide a lot of educational opportunities such as this, our regional conferences, and our Children's Summit. We are, a key piece of what our work is collaborating and bringing stakeholders together to have conversations about what are the needs for system-involved families. And then our cornerstone work happens with our Through the Eyes of the Child teams, which are multidisciplinary teams that are judge-led that cover every single county across the state of Nebraska to work on and address needs of community members and people that are involved in the court system on a local level. So at this time, I'm going to turn it over to Mary Pat Coe to lead the conversation. Thank you for being here.
Thanks, Deb. Okay, so we are going to cover bills that have passed and also discuss a few legislative resolutions. And our first person to talk about bills is Dennis Marks. Dennis is a deputy public defender out of Sarpy County. Thanks for being with us, Dennis.
Thanks, Mary Pat. Can you hear me okay?
I can, loud and clear.
Okay. Used to having to use the microphone in the courtroom anymore. So. Okay, so I guess the first bill up, now that we're off and running, was LB 1051. It was kind of a cleanup bill from prior legislation. I think if you look at it, what you'll see is some sections that were sunsetted were actually deleted now. And I'll give you an example. If you know, in the prior sections, if you looked at 43-251.01 subsection 5, subsection A, that was the old standard for detention that allowed for secure detention if the juvenile was a flight risk or a danger to themselves, others, or other people's property. That section has now been deleted, and now what was section B has now been renumbered to section A. So when I talk about the bill that renumbers, it's not that the statutes themselves or the sections have changed. They just have a new number. And another example of that would be if you look at section 43-248, that's when law enforcement takes temporary custody of a juvenile. Subsection 2, which dealt with if a juvenile was seriously endangered in their surroundings and immediate removal appeared to be necessary for the juvenile's protection, that now becomes subsection 6. And then subsection 3, which dealt with mental health and dangerousness and law enforcement taking custody of that juvenile, now becomes section 8. So that's kind of what I'm talking about. And you're going to see that in other bills as well. especially when we get to talking about LB 184. The next bill that I've been tasked to talk about is LB 1085, which was approved by the governor back on April 15th. And really, that only affects the separate juvenile courts, and I think more specifically SARPI. If you recall, what the prior statute held was that a separate juvenile court, if a county had a population of 75,000 to 200,000, they were entitled to 2 judges. Well, this new bill keeps the bottom figure of 75,000, which is good news to Hall County, but it raised the backside limit from 200,000 to 300,000. Why Sarpy County is affected is because I think sometime in 2024, and if not this year, next year, Sarpy County would have hit that $200,000 or 200,000 inhabitant figure. So now they're going to get to 300,000 based on growth projections, but it's probably going to take 10 to 12 years to get there. And maybe by then they'll raise it to 400,000. We'll see. I won't be around, so you'll have to tell me if it does. The other limits also increased. So a county with 4 judges, it went from 200,000 to 400,000. It got raised. The front figure now is 300,000 and the back figure is 500,000 inhabitants. So Lancaster County is safe there. It's just going to take them a little bit longer to get more judges, because the third category was you're entitled to 6 judges. Before it was if you had a population of 400,000. Now it's 500,000 plus. Douglas County's been at that 500,000 figure since at least 2022. So that's that bill. And then we get to LB 184, which deals with the transfer hearings. There's really 2 statutes in play here. Section 29-1860, which deals with transfers from adult court to juvenile court, where cases are filed directly in county court, do a prelim, move to a district court, and then you try to transfer a case to juvenile court. And then Section 43-274, where cases initiate in juvenile court due to the nature of the offense, and then there's a motion to transfer to adult court. And it's just not, we're seeing cases being transferred to county court as well. It's not just cases being transferred to county court and then district court. So what they've done here is they've addressed the admissibility of juvenile statements, particularly in evaluations. So these are new sections that have been created, and they're Section 5 in both statutes, and they're the same thing. They just mirror each other for the respective jurisdiction, whether it was filed initially in adult court or in juvenile court. So if a juvenile makes a statement, a confession, or admission for the purposes of a transfer hearing, and the statement, confession, or admission is made to a psychologist or a psychiatrist or a therapist or a licensed mental health provider, subsection 5A in each statute says that those statements are inadmissible in other criminal proceedings and civil proceedings, subject to the new section, subsection 5B, right underneath it. And subsection 5B underneath talks about when those statements are admissible, and they give really 4 examples. They're going to be admissible in a transfer hearing, so that might seem obvious, but that was necessary language to be put in there. If a case is filed in adult court and it gets transferred to juvenile court, those statements are going to be available, those confessions, those admissions, at a disposition hearing in juvenile court. If it's filed in adult court and it's not transferred, it's retained in adult court because the sound basis exists for that retention, then those statements, admissions, and confessions can be used in the PSI on the adult court case. By the same token, these statements, admissions, and confessions can be used in a juvenile transfer hearing. If the case is retained in juvenile court, then those statements, confessions, admissions can be used at the disposition hearing. If, for instance, that case is then transferred from juvenile court to an adult court, whether it be county court or district court, those statements, confessions, admissions can be used in a PSI. In both situations, the fourth situation is for impeachment purposes on cross-examination of the youth. So if the youth testifies at trial or during the course of a juvenile proceeding, and that youth's testimony is materially inconsistent with the statement made to the psychologist or the psychiatrist, the therapist, the licensed mental health provider, then that youth can be, and those statements were made for the purpose of the transfer hearing, then that youth can be impeached with that material inconsistent statement. My only thoughts on that is it seems as though the experts or the evaluators are kind of limited. I wonder if, for instance, if defense counsel needed to get a LADAC because the nature of the offense and perhaps the treatment was going to involve substance abuse treatment or counseling, if the LADAC was utilized, what happens then? I'm wondering about a neuropsychologist. I would imagine that they could probably come in because they're considered part of a psychology, but I don't know. And it's something that'll have to get worked out, I would imagine, in pretrial. But the use of the inconsistent statements really gives me pause. I've always had pause to whether or not my client should testify in a transfer hearing, and I typically don't do it. I like to get their testimony in through other witnesses. But if they're impeached, it really damages the credibility of the client's testimony. Any kind of expert testimony you're going to have from that report and the report itself. So I think the impeachment provision in there is something that is going to give pause to the practitioner to consider in deciding whether or not to have that youth testify. So I know we have a couple other people talking on this section. I look forward to hearing what they have to say. So with that, I'm going to turn it over to you, Mary Pat.
Thanks, Dennis. Next up is Ashley Peters. She is the policy administrator for Nebraska HHS.
All right. Thanks, Mary Pat. So the first bill that I'm going to talk about today is LB 876. LB 876 adopts the Newborn Safe Haven Act, and there are two major changes that are made from the current law. The first one is that it expands the age of the infant from 30 days old to 90 days. And the second biggest piece of what this changes from the current law is that in the current law, the only drop-off location is a licensed hospital. Within the new bill, there is language that it can be an employee on duty at a staffed fire station, a staffed law enforcement agency, and also the baby can be left with an emergency care provider. So those are kind of the two biggest changes that this bill does. There is also language in the bill that appropriates funding to the Department of Health and Human Services. And there are several components that we have to implement for a public information program. And the next one that I am going to talk about is LB 1412. So LB 1412 was actually originally LB 1209, but it got amended into a very large bill, the appropriation bill, which is LB 1412. So what this bill does is it appropriates $2 million for a grant to enhance emergency shelter facilities. The main goal of this bill is to improve access of services to both the child welfare and juvenile justice involved youth. There is also language in the bill that talks about it has to be implemented the grant has to be provided to an agency in a city of the primary class. So this bill will be focused on being implemented in Lincoln. And I think that is all I have, Mary Pat.
Thanks, Ashley. Appreciate your insight on that. And I just have a quick question. So are you saying it's only going to affect Lincoln? That's where
That is our understanding, yes.
Okay, great. Thanks. That is good to know. Next up is Elizabeth Einen-Koperda. She is the managing attorney from Education Rights Council. And as you can see, there was actually quite a bit that passed that's going to affect our kiddos in the education world. Go ahead, Elizabeth.
Thank you, Mary Pat. You can hear me, right? I just want to make sure.
Yes, I can hear you.
I tend to leave my mute button on when I'm not supposed to. Okay, so I'm going to talk about 3 bills that passed that have some impact, and then maybe 3 LRs that are going to be of interest. The first bill is it's actually LB 1193, as it says here, that was amended into LB 71. And what this basically does is give parents a right under limited circumstances to hold their children back. What we were seeing educationally, and I think many people have run into this, is we have children that miss excessive amounts of school for a variety of reasons. And what happens is then the school will come and place them at their age level without regard to what they've missed. So we had a child that was referred, for example, we accepted representation, we were appointed by Douglas County to a young man who had had high anxiety, depression, had not attended any of his 9th grade year. And in about October of his 10th grade year, through the system, et cetera, we got him re-enrolled. And the parents wanted him to be able to have a 9th grade year. And the school district placed him at, 10th grade, second semester or second quarter. So he basically missed out on that. And of course, then began struggling to catch up on all of what he otherwise would have gotten. So that sort of type of situation was the underlying purpose for this, as well as young children who are well behind in their abilities to read. So what this does is basically say, there are 3 things that can permit a family to make a determination to hold back a child, because prior to this, there was no law that would permit a family to make that decision. So the family, if there are academic needs, which means a child 4th grade or less cannot read at the ability necessary to succeed at the next grade level, and again, this is our young kids, or has missed 50% of the school year, or has been hospitalized for more than 2 weeks, resulting in this negative impact on school, the parent has the option to request that the child repeat the grade. For grades 5th through 12th, the only time that the parent has the option is if the child missed 50% or more of the school year. This was seen as sort of both a parents' rights bill and as a child's rights bill when it passed, because there were too many children in the system that were really struggling to meet the requirements of the court, and or parents to meet the requirements of the court, when a child that was so far behind was struggling to catch up and just didn't want to go to school anymore because it was too hard. So that's LB 1193. The next bill I want to talk about is 231. Again, it was incorporated into LB 1329. And what this does is direct schools to evaluate students with excessive absences before referring them for prosecution. So essentially, Right now, there is a requirement that before a child be referred to the county attorney, the school district is supposed to develop a plan concerning attendance. The way many of you have probably seen this implemented is they reach out to the parent after, say, 5 days, 10 days, 20 days. They send the parent community resources. Maybe they let them know what they are. And then if nothing happens, they refer to the county attorney. So that really isn't a great plan for attendance. What this does is amend the plan. So it says that the plan shall include, if agreed to by the education decision maker, an education evaluation to determine whether there's any intellectual, academic, physical, or social emotional barrier that's a contributing factor to the lack of attendance. I think this is going to be an important indicator for both county attorneys and public defenders. County attorneys may look to this as basically a resource to determine whether they want to file, and public defenders can look at this as a potential defense based on potential charges if the school hasn't done that evaluation. And where this arose out of from Education Rights Council's perspective is many times when we are appointed to do education representation by the juvenile court, we find that the entirety of the reason behind truancy / lack of attendance is an evaluation that didn't take place that needed to take place so that services so the kid could access school. So we're trying to, in this bill, make sure that there's a real plan. That's it. I see thumbs up coming. That makes me feel good. I don't know how that's happening, but I'm going to run with it. All right. The next bill that now clapping. You guys, you're great. Okay. The next thing that is I'm going to talk about is LB 855. This was introduced by Senator Conrad, and many of you might not know that this was happening, but schools were referring school lunch debts to collections. So Lincoln Public Schools, Kearney, Columbus, Scottsbluff, among others, were using private collectors to recoup unpaid lunch tabs. So, for example, a kid in Lincoln racked up $194 of lunch fees, and the parents didn't pay $53 of it. So Lincoln Public Schools actually referred them to a collection agency, which sued them. This, of course, is really problematic for our families in poverty, our low-income families. It doesn't do much good, and it can harm kids. Kids shouldn't have to go hungry. There are ways that we can provide free and reduced lunch. In any event, what this does is basically prohibit that school. You might try other ways to collect school lunch debt, but you don't turn them over to private collection agencies that then sue the families. Okay. I think I have one more that I was going to talk about that's not on here. Mary Pat, do you want me to talk about LB 1029 or not?
Go ahead, Elizabeth. You're right. I left that off. I think someone else is talking about it.
Oh, then I'll skip it. That's fine.
Okay.
I'll skip it. Okay. Then there are a couple bills that we want to talk about in terms of LRs that are coming up on the horizon that may be important that you might want to participate in. The first one is coming out of basically what happened this year with regard to special education, especially because we had a shortage of special education teachers. The legislature had a special session actually regarding specifically the Omaha Public Schools because they actually closed 3 schools to any kid that had special education needs because they did not have the providers. One of the reasons then what happened is all these kids went to other schools and student teacher ratios grew. So they're getting maybe some services, but in very larger settings. So the first LR is, should we have student teacher ratios? If we should have student teacher ratios, should they impact all classrooms? Should they impact special ed specifically? What does that look like in other states? What do other states do to address, I'll call it overcrowding of classes that serve special education students. I'll give you one quick example just because I'm prone to telling stories. We had a student that was appointed to us, and she had been struggling. And the question was whether the school should actually verify her for educational supports and services through an IEP, which means she'd actually get instruction, or just give her some accommodations, which you can do through something called a 504 plan. So it's not an IEP that provides instruction. It's just accommodations. And the school district literally said, if you put her on an IEP, even though she's probably eligible, what will happen is she'll end up going to this very large co-taught class, and it's going to be worse for her, not better. So that's an eye opener as to maybe student teacher ratios are something we should start thinking about. The second bill, or LR, is option enrollment. Last year, Senator Conrad introduced and had co-sponsors, but the bill passed that said, if you're going to deny a child the right to enroll in a different district, and we talked about this last year, sometimes that's very important for some of our children in the system. One district is just not a great fit for that child, but if that child has a disability, the districts were able to simply say, no, we don't accept anybody that has an IEP or might need an IEP. We're full to, quote, those kids, end quote. That changed, and now the LR is to study how schools responded. How has this worked? Are we actually seeing more openness? Is this appropriate? I mean, what's the effect of what we've done? So I find that heartening. I'd like to see that. And the last one that I think is really interesting is a ban and bar LR. Right now, school districts they're creatures of statute, right? So they only can do what the law gives them, the authority the law gives them. There is a general authority that is granted to school districts to basically run their businesses as they see fit. And it's really aligned to, all basic business decisions that a school district might make. But what happens is because entities can ban individuals, school districts ban parents and sometimes ban children, and there are no frameworks for this. So I have had the experience of parents who have been upset with a school district, and the school district simply says, you may not ever come on our campus for the entirety of your child's career on this campus. Right? So that could be 4 years or more. There's no appeal process. There's no requirement that there has to be a danger. There's no requirement. So, can I see that it's appropriate to ban somebody who is a sexual predator? Well, yeah. Okay, fine. But can I see that it's appropriate to ban somebody for 4 years because they dropped the F-bomb to the principal? That's the challenge. So there is going to be probably a lot of stories at this LR about what's happening to students and parents from education rights perspective. This is important because it's yet another thing that sometimes stands in the way of children accessing their education. In addition, we have from time to time seen ban and bars placed on students, which if the student needs to be disciplined for a behavior, the student should be disciplined pursuant to the Student Code of Conduct, which does have due process. There is no due process for ban and bar. It should not become a substitute for utilizing the tools you've been given, which is called the Student Discipline Act. So I think that's a summary of what I was going to talk about. Mary Pat?
Thank you, Elizabeth. I do have a couple questions for you. One from our participants. How do you think the teacher shortage will affect LR 319 and the student-teacher ratios? Any ideas?
Well, I think it's really interesting because what we sort of saw over the year is teachers advocating for this, advocating for ratios, but districts advocating against ratios. I think it's going to be a real discussion about what's best for the children, especially in the special education world, because unlike the general education world, when you are working with children who have a right to services, that's a federal right, that has been adopted by the state so that the state collects the funds from the federal government. And now we've seen this significant increase of special ed funding that Governor Pillen signed into law. There's going to be some questions about why can't you at least ensure ratios for our most vulnerable students. And my gut is that the teachers will be advocating for that. So it'll be interesting.
Great, thanks. And Elizabeth, I have one more for you. When you were talking about LB 231, I think you made a distinction that was the educational decision maker. Can you kind of tease that out for me just to make sure everyone understands why you didn't just say parent?
Absolutely. So because we're a good old fashioned state, lots of our laws say parent, right? But as we all know in the juvenile system, many, many times the parent is not the guardian or caretaker or education decision maker. And we either appoint an education decision maker for the child, who is maybe the foster parent or maybe the guardian ad litem or maybe a lawyer that is appointed separately by the courts. And that arises out of a variety of situations, right? And my favorite one is I was appointed to a child whose father had sexually assaulted her and he was in jail with a no contact, but he still was the only one that had education decision making. So that had to change. But we want to make sure that whoever makes those decisions has the right to participate in this particular statute as opposed to just the parent. And if there is no parent in charge, then what? Does that make sense?
It does. Thank you, Elizabeth. Okay. And Elizabeth, I'm going to reserve the right to possibly come back to you.
I'll stick around.
Perfect. And just so you're prepared, we may be chatting a little bit about LB 25.
Okay.
All right. Okay. Next up is Judge Elise White. She is on the separate juvenile court bench in Lancaster County. Judge White.
Thank you, Mary Pat. Good afternoon, everybody. There are two bills that I've been tasked to talk about. The first one, Dennis did a really great job covering this pretty comprehensively. So the only other thing that I'm going to point out with regards to the bill with regards to inadmissibility of statements during transfer proceedings, just from the juvenile court transfer proceeding perspective, there are factors that the juvenile court is tasked with considering and weighing when looking at whether a case should be transferred to adult court. And I think that this statute is designed to try to help maybe alleviate some of counsel's heartburn with getting an evaluation prior to that transfer hearing, specifically for the factors of the type of treatment that a juvenile will be most likely be amenable to, as well as consideration of the juvenile's ability to appreciate the nature and seriousness of his or her conduct. I know that just sometimes with these hearings, it's difficult to find information outside of having the juvenile evaluated for some of those factors to be considered. And so I think that those are two areas in that transfer area where this statute's hopefully going to kind of alleviate some heartburn counsel might have in looking for a pre-adjudication evaluation. The other bill that I was tasked with speaking about today is Legislative Bill 1029, which was approved by the governor April 15th. What this bill does is it adds language to Nebraska Revised Statute Section 79201, and that would be sub 2 of that statute, which talks about when an absence is excused, and it includes language so that school authorities would excuse an absence when it's mental or physical illness. I think previously it had been physical illness, and they included that so that a mental illness would also be an excusable absence. And I'm sure Elizabeth probably has some other information that she can maybe add with that as well. But that's the kind of the big change that occurred that we'll see in 79201 that was passed with 1029.
Great. Thank you, Judge White. I appreciate that. And since you did kind of throw that out to Elizabeth, a little bit, and I did take that off for Liz, I'm going to have Elizabeth come back for me because I'm wondering, Elizabeth, on 1029, since this is, in your wheelhouse, how would you go about getting that in front of a judge if the kiddo ended up, in a court situation with the mental illness? What kind of, evidence or, what would you use in a case that you were specially appointed for?
Thanks, Mary Pat. I think that what so I wasn't really involved in the underlying creation of this bill. I think that what Senator Conrad was just most concerned about is that all it said before was illness. So in other words, if there is an illness, we'll excuse you. And I think what her concern is that she'd seen too many schools say a mental, even going to a PRTF is not an illness. And so it's an unexcused absence. So you haven't been here, so we're going to refer you. So from my perspective, what I thought she was trying to do was make it clear that illness is invisible as well as visible. It's not just throwing up, right? So that's where I think she was going, so that when somebody says, my child wasn't here and I can show you that they were receiving therapy because they have FNB and they really literally could not get to school, that is counted as an excused illness and not referable. That's how I'm seeing it.
Great. Thank you. Thanks, Elizabeth, for letting me throw you under the bus there.
Sorry, I don't know how I would use it per se, other than to say in a court situation from an education perspective, I would simply say this is more argument that either my child, should sat term or shouldn't be prosecuted or needs a co-occurring, or, there's multiple things that might happen there to make sure that we're meeting the child's needs, instead of saying you're truant and that's bad.
Right. Thank you.
Mary Pat, can I jump in here?
You may, Dennis.
Well, I will tell you, 30% of my caseload is truancy cases. And a lot of these kids that are coming in, virtually all of them have been touched by COVID in some way. And for a lot of them, the socialization piece kind of knocked the domino over for the mental health. So a lot of them are talking about school anxiety, being amongst a large number of kids, large classes. And so I think probably what the addition of the mental health piece is so that defense counsel and county attorneys can look at if there's some mental health documentation. And sometimes not all that documentation is given to school. Some of it is collected after the fact. But I think that if we can get that information, if the schools can get that information, take that into account in counting towards the number of days towards truancy, I think it might end up reducing the number of truancy referrals, because, and my counterpart, Bree McLarty, can talk about that if she has time, about just the number of truancy cases that have just exploded. And I don't think Sarpy County is any different than any other county.
Great. Thank you, Dennis. Thanks for chiming in on that. And we definitely will have time. Remember, we go till 1:30 on this webinar, so we definitely will have time to hear Bree's take on it. Right now, we're going to send it to Sarah Helvey, who is the staff attorney and director of the Child Welfare Program for Nebraska Appleseed. Sarah?
Great. Thank you, Mary Pat. And hello, everyone. I want to thank Court Improvement for the opportunity to present today. I always enjoy this. None of our priority child welfare bills passed this session. As others have mentioned, some important things have passed, but none of the ones that we were really working on or prioritized made it across the finish line. Wah, wah. That's how it happens sometimes. So I'm just going to mention kind of next steps for one, and then an LR. So LB 945 was a bill that we did a lot of work on with Senator Hughes. And that bill sought to address access to vital documents for young people who exit care. So it was based on feedback from young people who had shared that they are still missing access to some of their vital documents necessary for them to obtain a job or enroll in post-secondary ed. Existing federal law already requires states to provide young people with their birth certificate, social security card, health insurance information, medical records, and a driver's license or a state ID when they age out of foster care. And then also Nebraska law expand on this to include additional documents and information. But in the 7 years since that law was implemented, young people have identified that they're not always getting that information, number one. And number two, they identified additional gaps in access to certain information that they need. And so LB 945 would have addressed those gaps by requiring HHS to provide them with FCRO reports, case numbers and court records for them, available photographs, a written explanation of the reason the child came into care. We often hear, as I'm sure many of you have as well, that young people don't even understand the reason that they were in foster care. So wanting to have clarity around that or sort of misunderstand that. LB 945 would have also clarified that medical records, which are already required to be provided under existing state and federal law, but that includes documents related to psychological care or evaluations and a list of providers that the child saw while in care. Because so many times that they are affected in their continuity of mental health treatment when they age out of care. And then the bill also specified that educational records include award certificates and grade reports. So things that young people need or just long for from their time in care. And then also would have permitted the child or their GAL to request that the child be given access to additional documents that may come up on a case-by-case basis, but require the court to make a determination that access to that would be in the child's best interest, and then an opportunity to redact information if there was any concern about sensitive information. The bill was referred to judiciary and voted out unanimously, and was placed on consent calendar. So we really thought it was going to pass this year, but the body ran out of time. And so we are hoping to work with HHS in the interim to improve some of those procedures administratively. But Senator Hughes is committed to reintroducing that if needed next session. So one to look for, and if you have any, information from the field or feedback on that in the interim, we would love to hear it. Speaking of interim, there's also an interim study that we will be working on, and that is LR 390, which was introduced by Senator Brewer. And that one is focused on whether Nebraska statutes should be changed to officially recognize tribal customary adoptions. And tribal customary adoptions, yay, got the thumbs up and clapping emoji too, Elizabeth. Tribal customary adoption is an adoption that's recognized by a tribe, which gives a permanent parent-child relationship with someone other than the child's birth parents. And importantly, they don't require the termination of parental rights of the birth parent. And several or maybe all of the tribal codes in Nebraska permit tribal customary adoption. So the question is, what changes need to be made or should be made to Nebraska statutes to accommodate this? And so we'll be working with the NICWIC, the Nebraska Indian Child Welfare Coalition, and the tribes, as well as the ACLU and others on this interim study. And with that, I will turn it back to Mary Pat.
Great. Thanks, Sarah. We appreciate it. And I know I do have a couple questions in the Q&A. And I'm going to first have Bree present, and then we'll circle back around to you. So Bree McLarty is with the Sarpy County Deputy County Attorney's Office. Bree?
Yes. Hi. Good morning, everybody. I hope everyone can hear me. Someone will tell me if they can't. All right. So I'm going to start with 1051. We've already talked about this a little bit. This came out of a legislative resolution or interim study that Senator DeBoer had kind of brought forward, because if you read the juvenile code, it's interesting. It's quite a read. And there was a lot of superfluous language with those sunset clauses that were really just kind of clogging it up. So being able to remove a lot of that from some of the huge overhauls that happened in 2014 and 2017 was a huge help to just make it a little cleaner to read. But the one thing, I think Dennis touched on this briefly, but one of the things that changed specifically is the basis for removal statute. I think that's LB 43448. And what it kind of did is it used to just be like, as we added them. It looked at grouping them and kind of where those removals end up kind of creating cases. So right now it's a little bit of a mess, but with this change, what it does is it kind of groups all of those law violation, delinquency cases that kind of end up with the juvenile probation case. So like your law violation, runaway, violation of probation, truant from school, those are kind of all grouped together, because what happens is a lot of these, this statute specifically, 43, 248, is cross-referenced in so many other statutes about what the next steps are. And it was so difficult to go back and kind of track it. So now knowing, 1 through 4 is that kind of, law enforcement removal that will likely end in what's called a delinquency case or a status offender. Now we kind of know 1 through 4, that's what that is. Then we have 5 was a juvenile that, you may think is involved in prostitution. Then subsection 6 is the endangered juvenile. And this is your classic law enforcement removal that starts a temporary custody and a 3A juvenile dependency or neglect case. Subsection 7 is now a law violation where the child's under the age of 11, which would automatically be a 3A because a child under the age of 11 can't be charged with a criminal charge. And then the last one is when law enforcement believes that a child might be mentally ill and in a state of crisis, that would typically end up in a 3C case. So it's just nice that they're kind of grouped together. So as you're looking at where they're cross-referenced, it's going to be a lot easier to remember which is which, because it was quite a struggle before. So I really appreciate the judges working really hard on kind of cleaning that up. I know I served on that interim study panel, and there's a lot that we're still looking at or that we're talking about. So I'm glad they were able to get something done, get it narrowed to something that could be passed, and that it's going to make at least the removal statutes and what comes after so much easier to read. The next one I'm talking about is LB 184. This is a perfect example of why it's so important for all of us to be involved in the legislative process. I serve on the legislative committee for the county attorneys. I'm their juvenile representative. And I saw this and, immediately some of the criminal defense attorneys were like, oh, absolutely. Or criminal prosecutors, like, absolutely not. We don't like this bill. We hate it. I'm like, well, let's look at it. Let's look at what the juvenile might be, why they might want it. So we had a conversation with Senator Kavanaugh. He was so open about kind of why he used to do public defense work in Douglas County. He's like, sometimes you look at a kid and you're like, this kid just needs to be in juvenile court, but I need that evaluation to explain to the judge why he's better suited in, or he or she is better suited in juvenile court versus adult court. But how the bill was written was, it said, any statement made to a evaluator, and then anything that came out of that evaluation, you can't touch. You can never use it. You can never bring it up in a court hearing. And I talked to Senator Kavanaugh. I'm like, I get where you're coming from, but the problem is how you drafted this bill is now we can't use that evaluation for disposition. So say you are successful and the kid comes down to juvenile court. Now I have a psychological evaluation that has all these great recommendations about how to help this kid, but I can't use it. And anyone that has fought with Medicaid or health insurance knows that getting another psychological evaluation or that type of evaluation within a year is impossible. They'd have to pay out of pocket. So we were able to go back and forth with Senator Kavanaugh and kind of make sure that unintended consequences like cutting off that evaluation from ever being used didn't happen. But we're also able to go back and forth to say, okay, we get where you're coming from. We're going to give a little bit on this, but we'd like you to add the impeachment issue, because the last thing we want is a kid saying the evaluation, what they say, then going on the stand and saying, I didn't say that. That's not what I meant. So it was kind of a nice balance. No one got everything they wanted. We all got a little bit of something. And I think going forward, obviously how 184 plays out, we might see some unintended consequences. We might need to make some tweaks to it, but it's just a perfect example of look at the bill, bring the issue to the introducer about maybe something you're noticing about it, and hopefully you guys can come to a resolution. This was one where the county attorney started opposing it, and by the end of it, we were in support of the bill because he had worked in good faith with us about some of our concerns. So excellent example of why we're all here and how we can make a difference and kind of work towards good legislation that can hopefully meet everyone's needs to make the juvenile court process work better. The next one I want to talk about is LB 1029. I know we've talked a little bit about this, so I'm going to kind of come from a county attorney's perspective. Adding the mental health as encompassed in that word, illness, I think is going to be really helpful because everything runs downstream. If you're now saying that illness includes physical and mental health, I think Elizabeth was the one that said, visible versus invisible. Making that clarification means that as a county attorney, when I'm looking at that referral, I'm going to say, okay, did you ask about mental health? Did you ask to have the parent sign a release so you can coordinate with their mental health practitioner about their anxiety and ways you can accommodate that. Did you make sure that you excuse those absences when they were going to seek mental health treatments? Not everyone can meet after 5 o'clock. So sometimes you have to miss class to go to that evaluation or to go to those sessions. So that's what I'm going to be looking for. And now it's not a get out of jail free card. It's not it's excused. Excused can still count towards excessive absenteeism. But knowing that that's something that the school's going to have to accommodate, especially when we're looking at how this will work with LB 231 as adopted, I'm going to start looking for that. It's like, did you actually try to accommodate? Did you actually try to plan with this child, this parent, about how you can make sure their mental health is not a barrier to receiving educational services? So this just helps give me a little bit more to be able to push back on the school and make sure that they're doing their due diligence. But then also, like Dennis said, when we get the evaluation, sometimes school isn't provided that, or maybe the parents aren't forthcoming about that information or communicating. We've seen, Dennis and I have had a couple of these cases where sometimes there's just bad blood. The school and the parent, they have had enough of each other and they don't want to talk. And unfortunately, it turns to Dennis and I to be almost like marriage counselors to try and get them to talk and coordinate and to get that information. So that's also something to think about when you're looking at defense or prosecution is, do you have everything? Do we know how we excluded mental health as one of the reasons why this kid's struggling with attendance? So I think it seems like a very simple change, but I think it's really going to snowball into a bigger focus by all parties involved. We're trying to address truancy on, are we making sure that we're evaluating mental health and we're providing that support? And, if it is one of the cases and maybe the parents are trying, the kid doesn't want to engage, that's just going to help us going forward if we do proceed with prosecution and adjudication to make sure that that's codified, that that's reflected in the PDI and reflected in what's been tried up to that point. So at least when they're on probation, we're hopefully more successful and we can not try things that have been tried in the past that weren't successful, if that makes any sense. So that's kind of what I want to talk about briefly with LB 1029. And then the last one is legislative resolution LR 342. I'm so happy that this was introduced because I think this is something we're really struggling with. And there's a lot that can be done with this. I think one, looking at the 3C jurisdictional statute would be a huge undertaking, but something that's so desperately needed. It's trying to be mirrored off of the adult commitment statutes, which is when you talk about someone who's involuntarily committed because they're in such a dire mental health crisis. They try to use those adult statutes and kind of squeeze it in and pitch it into the juvenile code. But there's so many differences about what's possible in the adult world versus the juvenile world, not only with statute, but also with available resources. If you're talking about that on an adult side, there are psychiatric wards that they can be committed to. You're talking about the Lincoln Regional Center. We don't really have those in the juvenile world. We have Emmanuel in Boys Town, but those are private entities that can decline to keep those juveniles. It's completely voluntary. The parents consent to the treatment, and the 3C can exist to maybe override those parents' wishes if it's really that bad. But that's it. We don't have the same resources and the same capacity that an adult does. We're trying to pigeonhole it in juvenile court. So the 3C is kind of one of those weird statutes where it's there, we barely use it, it's not really effective, and it definitely is not effective in getting immediate intervention for juveniles that are in a state of mental crisis, at least not one that we can support through the juvenile court. The other part I want to talk about is we have some of these community-based resources, like Region 6, there's a rapid response program where kid can't be involved in the juvenile court. So maybe it's an intake comes in, or I hear about it. I, as a county attorney, can make a referral. This kid gets to jump to the front of the line. And it's great because they get a case manager, they get immediate access to a psychologist. Anyone that's tried to schedule with the psychologist knows sometimes it's weeks, months. So it's a great program. The problem is it's income limited. So I have kids that are in an active stage of crisis and we can't help them with this program because their parents make too much money. But their parents don't make enough money to walk into a psychologist's office or a psychiatric office and demand an appointment that day. So we have actually a group of kids where they have health insurance and their parents are fluent, but that doesn't mean they get mental health services quicker, and they're in an active stage of crisis. And sometimes these crises lead to property damage, physical danger to others. And then at that point, we're looking at detention, and we all know that's not where they belong. So I think really looking at making some of these crisis interventions available regardless of income status, looking at, is there a way we can fix the 3C statute to actually be beneficial? And I know that LR specifically looks at investments for juvenile-based inpatient services. Right now, we're at the mercy of private entities, and sometimes they can decline and they can deny our kids that desperately need help. I think I've had more kids that have been recommended for PRTF facilities, which are psychiatric residential treatment facilities, that I've ever had on my caseload, and Emmanuel and Boys Town are just denying. And so we're having to look out of state. And unfortunately, sometimes these kids are sitting in detention while we wait because they cannot be safely returned to the community, even with the services we have available. It's heartbreaking. I don't want to have that. I wish we had a state option, or at least a state option of last resort, just so they can get some immediate interventions. So I think the LR is going to be huge. I really hope the Judiciary Committee takes it up and really starts listening to what we're seeing on the ground here in juvenile court. Dennis hit the nail on the head. COVID has definitely changed the trajectory of a lot of these kids' lives, unfortunately not for the better. And we're all kind of dealing with the aftermath of that right now. So I think to the point that anyone could put pressure or contact Senator Boston as well as the Judiciary Committee about having a hearing or at least soliciting information, it's very necessary. This is going to be a long-term problem that's going to require a lot of work over many sessions to get to the bottom of. And I think this is a great place to start, but it actually has to start. So to the point that you can be involved, definitely be involved, because I know we're seeing it here in Sarpy. I saw it in Dodge County, my previous employer, and I'm sure we're seeing it across the state. So that's kind of all I had to talk about. I'm happy to answer any questions, or we want to do back and forth about some of the cases we've already discussed.
Great.
Bill, sorry.
Thanks, Bree. I appreciate that. And I'm going to see if I can put this in the chat. I believe, and maybe if somebody online knows about this too, that the Department of Justice may be having some town halls in, I believe, Omaha, Lincoln, and Kearney. I'll try to get that information out in the chat for everyone. Now, we do have a couple of questions out there. One for Sarah. And the question is, would the parent retain the right to return custody on demand in a tribal customary adoption if parental rights remain intact?
I don't feel like I can answer that definitively because number one, I am just starting to research it. And number two, I would never, that there are hundreds of tribes and tribal codes, and I, can't cover all of that ground. But what I can tell you is that the other state statutes that I have seen use the term suspension of parental rights, and that refers to a permanent suspension pursuant to a tribal court order of all rights, powers, privileges, duties, etc. So that in that scenario, my take on that would be that it doesn't permit a birth parent to request that the child be returned upon demand. And just for a little bit of context, I mean, the idea behind tribal customary adoption is that it's more culturally appropriate. Many tribes don't, recognize or believe in the practice of termination of parental rights. It's not part of their code. And so, and has, historically trauma associated with it in terms of forced assimilation policies for tribes. And so this is a more, culturally appropriate response. And so again, the goal of the interim study is to look at how we might need to change our state statute to recognize this practice within tribal codes and tribal customs.
Great. Thanks, Sarah. Elizabeth, I'm going to bring you back. We have a question in the chat. Someone's concerned with when we're talking about mental health, especially when we're adding mental illness to the physical and mental illness for excuse, of concern of having a school maybe having mental health records of a kiddo. And do you see any pitfalls there or other ways to handle that?
Well, one of the things that we have always, from the juvenile court perspective, included in orders when we are appointed, is the authority to release those portions of evaluations that are necessary and appropriate to get services. So I might not be answering this fully on point, but the way we've handled this is that when there are mental health records, they are not provided wholesale to the school. They, especially if there's, background about family or other family members, things that are not appropriate or needed in order to provide school services. So I often will maybe take the paragraphs that describe the DSM-5 diagnoses and include that, and basically black line, redact the rest, and or only provide those pages that are appropriate. So I'm not sure how other people would be able to do that in their respective positions as public defenders, county attorneys, et cetera. But we have court orders that allow us to limit what we provide.
Okay, thank you. Also, if I can take you back to LB 71, and when you were talking about, parents now having a little more say in repeating grades, does that also include an educational surrogate?
Yes, it would. It would be whoever is the education decision maker. Yes.
Okay, great. And I know you we're kind of going back and forth on, I believe, LB 231 in the chat. Are you able to kind of summarize a little bit what the concern was there in your answer? So everybody knows that. I'm not sure if everybody's checking the Q&A and seeing your response.
Well, I was confused. There was a question with regard to how does LB 231 extend to students? I'm not sure I quite understood the question. So let me reread the chat. Or do you have a simplified version of that question, Mary Pat, that I can go to?
I do not have a simplified version.
All right. So let me read the question aloud and try to answer it.
Okay.
The question is, does LB 231 extend to any student that has excessive absences, permit those absences to result in not completing graduation requirements so that they may be able to return to complete those requirements towards graduation? I mean, I think all LB 231 does is if you are an enrolled student, and if your student has a right to be enrolled, even though they're absent, they should not be disenrolled. One of the plans that they're required to engage in prior to making a referral to the county attorney as part of their plan of attendance is to do this evaluation. So then the next part of this question is, at this time, for example, LPS does not permit students without special education services to return to complete these requirements if they have a year or more left to complete. That results in the student being forced to complete a GED program. So LB 231 is going to be limited to students who are enrolled. So I'm not quite sure which student you're describing here. So if a student has been unenrolled for a year and the school district disenrolled them, even though that isn't a thing, and they are 18 years old, they still have a right to enroll. And if they continue to be truant, they are, and at that point, I would be asking for an evaluation right away. I don't have to wait till them to be truant anymore. They have a right to that evaluation. Now, you are correct that if you do not have special education services, you don't have an automatic right to education until you're 21, but you still have the right to remain in school to obtain those extra credits. If you have, you can repeat your 12th grade year to obtain you can be a 5th year graduate or a 6th year graduate. So I feel like the question is mushed and I'm struggling to untangle it. Sorry.
That's okay. Thanks, Liz. I appreciate that. And remember, we go to 1:30. We want you to have the best bang for your buck here with information. So don't sign off and take the number with you. We're going to still keep talking about a couple LRs that I'm going to read read online. Also, then I'm going to come back to Elizabeth to talk about LB 25.
Ooh, tort law. My
Yeah.
favorite. I feel privileged. Let's do it.
Good. First, I just want everybody to know there's a couple LRs that you might be interested. LR 387 is an interim study to examine payment rates and methodology used by the Department of Health and Human Services for child and adolescent behavior health care, child welfare, and juvenile service providers. There's also an LR 405. It's another interim study to examine the process that DHHS uses in selecting a provider to service a foster home. And the last one, which this brings me back to Elizabeth, is LR 347. It's an interim study to examine the frequency of claims brought under the Political Subdivision Tort Claims Act and the State Tort Claims Act and the frequency of tort claims brought against other states. I'm not sure if that dovetails into LB 25, but I thought I'd throw that in. So Elizabeth, LB 25 did pass this year, but it got vetoed. So
Right.
what, if anything, can you share with us?
Okay. Well, just for our listening, what do we call it? Our avid listeners, I think we should back up just a little bit and from an education and tort law perspective, explain sort of the background, if that's okay. Because I'm not sure that LB 25 is exactly on point to the whole tort law claim issue, although it carried with it. So what we had effectively prior to 2020, and I'm trying to remember the name of the case, begins with an M. Moser, I think. Does that sound right? Moser v. State? Okay. Anyway, prior to 2020, we sort of had a split where the court was reading our tort claims law with regard to arising out of an assault language that is an exception to sovereign. Well, it says you may not bring a tort claim if the tort is arising out of this assault and battery language. And what the court had prior done, I'd say, at least in the education setting, that if the district itself basically showed negligence, its own negligence, there could be a claim against the district that was not prohibited by our tort claims immunity statutes. What happened in the Moser case is they basically reversed that. And what they essentially said is we are stuck with the statutory language. And the statutory language is arising out of. And so what has happened is even when an entity, I'll use an extreme, but we believe that this is actually possible. If I am a school district, for example, and I hire somebody who has a history of assaulting children, and then that individual assaults a child, there is protection from the district. They may not be sued for that because the basis of the lawsuit is arising out of an assault or battery. And so where Senator Wayne was with LB 25 is he introduced a bill that said this has to stop somewhere, and especially with regard to sexual assault. It was a broader bill than just school districts. It applied to all sorts of governmental entities. And I think that it got vetoed. I'm not going to speak to why it got vetoed, but what I would say is I know that this is an enormous challenge across a variety of institutions. And for my purposes, from an education perspective, it's just it's more than a bit offensive that that an entity could actually engage in a negligent act, and there's no way to basically hold that entity accountable. So I think that what we're going to see, like you said, there's this LR, Senator Wayne has said that he's not going to come back for a special session unless it includes these kinds of things. I think that there was a much more recent case. That's what Senator Wayne, I can't think of the name of it, got excited about. But I do think that this is extraordinarily problematic. Because if you read the language of Moser and the subsequent language from a couple court decisions, they effectively are saying, legislature, you wrote it. We have to implement it. And arising out of it is pretty broad. So this is how we're reading it. And if you don't like it, you need to change it. So I think that it's coming sort of to a cusp because every single time the Supreme Court says, sorry, arising out of, we see children and or families that are really being hurt with literally no remedy. So what that remedy will look like, I'm not sure. And I'm not sure this is what you wanted me to talk about, Mary Pat, but you gave me my soapbox, so I did. Did I answer any of the questions or did I take that where you wanted me to take it?
You did. Thank you very much. Tracy, I'm going to need your help here. I'm going to put in the chat the information. Oh, wait a minute. I guess I can do it to everybody. About the town halls that I mentioned. Let's see if that goes.
Mary Pat, while you're doing that, I can't speak to it in depth, but just to mention that there was a case last week before the Nebraska Supreme Court with regards to what Elizabeth was talking about, where DHHS knew that the foster parents had abused the child, but the tort was denied because it arose out of assault. And so I think, I did see in the news media that Senator Wayne was also saying this is reason we need to revisit that same language.
Well, thanks, Sarah. I appreciate that. Tracy, is what I put in the chat, did that go to everybody or just the panelists? Everyone. Perfect. Thank you very much. So if you click on that, you will see the town hall meetings. I believe it's in Omaha, Lincoln, and Kearney. There may be another location, and it's about the mental health crisis that the Department of Justice is, I guess, very interested in about in Nebraska. So I would encourage you to take a look at that. And if you can go, please do. Is there any? Yes.
Mary Pat, with regard to that, I was asked to speak on a webinar next week with regard to the impact of COVID on children in education. And of course, it significantly impacts, as we've heard Dennis and Bree talking about what has happened in the juvenile court system. I would be very, very grateful if anybody on this call wants to forward to me information that I can then literally pass on. I have like 10 minutes to talk about this, but I think it would be very beneficial for me to be able to present more than just my point of view. So if anybody on this call is interested in talking and telling to me very specific impacts that they are seeing in their walk of life with regard to COVID on children, juveniles, education, I'd love to get it. I think is my email somewhere there? I can put it in the chat.
It's not. Can you put it in the chat and make sure you put it to everyone?
Yeah. Is it in the Q&A or the actual chat?
The actual chat.
Okay. I'm going to do it right now.
Perfect. Thank you. Any other questions from any of the attendees?
Did that go to everyone? Oops.
Yes, said to hosts and panelists. So
that's okay?
I don't know. Is it?
That's the only thing I can send.
Oh, Tracy.
Can you just cut and paste it and put it to everyone? There we go. Tracy did.
Perfect. Any other questions? I'll give everybody a minute just in case there's another question out there. Okay, I'm just going to read this one. It's from Stephanie Neal. She says, I am the mental health provider for Holdridge Public Schools, and I would like to ask for any resources that you feel would benefit understanding of how the juvenile justice system works for youth with mental health concerns and to help me advocate and understand court proceedings. That is a big bite of the apple. Elizabeth, what can you throw in for that?
I'm trying to think about from resources. There are a million resources. You know what I'm going to do? You know who's the king of resources? Is Dennis Marks. But I would also say that, okay, great. Teresa's going to answer this question live. Go.
She is not, but you know that. Let me get that back up.
There are so many different kinds of resources. And the real question is, what will be most targeted for you so that you can be a strong advocate? And I think the biggest challenge that we see so many times is that children within the system, and especially invisible mental health disabilities, are not well understood. They're not well understood by the courts. They're not well understood necessarily by, on this group, many people do understand, but they're not necessarily, and the rights and obligations of what a school district needs to do to assess a child that is having disabilities that are standing in the way of their being able to attend is important. So basically just informing the court, informing the public defenders, informing the county attorney, informing the guardians ad litem. Those are the kinds of things that are really important to assist within the juvenile system.
Right.
I'll go ahead and jump in here, Mary Pat. I'm going to make a plug for the court improvement projects. They have your guide, and they have two. They have one for juvenile dependency cases. So these are your HHS, CPS, abuse and neglect cases, but they also have one for juvenile delinquencies. So if you are an outsider from the juvenile court looking into our weird, crazy world, this is a great resource to just understand what the different hearings mean. Difference between an arraignment or a first appearance versus a disposition or what we call sentencing. That way, where's the best place to maybe interject. I'm going to echo what Elizabeth said. Never feel bad about calling the county attorney or the public defender that's representing your kid to give them information. Obviously, I'd say if they're represented, go to their defense attorney first. But as a prosecutor, I feel like it is always helpful to know what a kid's struggling with, because that's definitely going to change how I approach the case. I would also say in your jurisdiction, look and see if they're looking for a mental health practitioner to serve on some of these committees we have. So, for example, a county attorney is required in their county to have what's called an 1184 meeting. It's an investigative and a treatment team. And I know we have mental health practitioners on ours to help us give insight. So as we're staffing cases, having someone to be like, this is what, oppositional defiant disorder means. Here's how it manifests itself. Or we're talking about, schools talking about behaviors they're seeing of this kid, like, we don't know what to do. Should we send them to court? That person say, whoa, this sounds like a way that their mental health is manifesting itself in a school environment. Let's take a step back. So see if there's a way you can get involved in that process. It's a lot. But if that's something you're interested in doing and making sure that your local jurisdiction is understanding and open to this kind of information, and you're willing to take on, it's a pretty heavy task, willing to take that on, I'd encourage you to do it, because I rely so heavily on those therapists that work on our MDT teams, because they just have so much great information and do a great job of really steering me in the right direction when we're looking at treatment and intervention.
And just a really quick clarifying, MDT from a county attorney's perspective is not an MDT from a special ed perspective. They're two different things, just for the school people.
Yeah,
that's all right. And
Thanks,
the teams of people that get together to try to help the child, as opposed to a team that's evaluating the child.
Dennis, I saw you had unmuted yourself. Did you have anything you wanted to share as well?
She steals the thunder. She is the gold standard for county attorneys who practice in juvenile court. So I was just going to say, the earlier we get the information, the better. It can really help the outcomes. So number one. And number two, you might want to investigate some committee work on the eyes of the child. I think mental health providers would be very helpful. For instance, if there's a community services committee, for instance. So I think you could be very valuable in contributing in either of those ways or both.
Perfect. Thanks so much, Dennis. And Stephanie, I'm going to have Teresa, since she's more techie than me, send my email to you as well. And happy to chat with you about how to get connected to your ICE team out in Holdridge. And also just kind of, how does the juvenile justice system work? Because it is its own world and hard to understand if you don't live in it all the time. I don't see any other questions. We're at 1:18. I think you got the best bang for your buck that we could give you with what passed and what LRs are out there. Again, thank you so much to the panel of experts. We could not do this without them. And obviously, I beg and plead for them to come back year after year, because I believe we do have the best people out here to let you know how this is going to affect your cases, your kids and your families, with what passes and what LRs are the most important that are out there. So again, thank you so much to everyone on our panel. Thank you for attending, giving us your time to hear about what's going on. So have a great rest of your day, and we'll see you next February.
Thanks, Mary Pat.
You're welcome.
Thank you, everybody.
Mary Pat, this is Tracy. There is one last question. Could you repeat the LR for customary adoptions?
The LR for customary adoptions, it's LR 390.